everybody. Good morning, good evening, good afternoon, anywhere you are in the world. My name is William Mougayar, and I'm going to be moderating this panel. We are talking about the new Swiss law, basically where Switzerland has given tokenized securities on a blockchain the same legal standing as traditional assets when they are being traded or transferred. This is a project that's been in the works for about 2 years. And what's interesting about Switzerland is that they decided to not create a new law, but rather to adapt to the existing ones. And they recognized that the capabilities of the blockchain, of which distributed ledger technology is a part of, they recognized it as an acceptable technology that can work without the involvement of intermediaries. So this is really the innovation. And we are here to discuss this law, how it came about, its implications, impact on Swiss and non-Swiss companies, and what the future might hold as we get into applying these laws in different aspects of business. And we have with us experts, lawyers, Luka Müller from MME and Andreas Glarner, who will be discussing and explaining to us this law in detail. We'll start the presentation with Andreas initially, and then Luka, and then I'll come in later, ask some questions. And in the audience, feel free to please enter your questions in the Q&A section of the Zoom. These are private to us, and I'll be selecting some of them as time permits. We will be answering as many questions as possible. So without further ado, I pass it on to Dr. Andreas Glarner.
Okay, thank you, William. Also, big welcome from my side. Thank you for participating in today's webinar on Swiss DLT regulations, focusing on DLT securities. William asked me to provide you with a kind of a glance overview on the historical aspect. So how did Switzerland end up implementing and amending its law and enforcing new DLT securities? And obviously, I don't want to make it boring, so I'm not going to go back for centuries. But as you know, Switzerland has been one of the jurisdictions which has been very active in the DLT, blockchain, crypto industry, starting already back in 2012, 2013. That's where our firm MME got involved, and we founded our team with Luka and Thomas and myself. And so we soon realized, and the regulators and the politicians soon realized, that something important is happening here in the technology side, which may have an impact on how in the future business is being conducted in the financial industry in particular, but also in other industries, and also with regard to how securities are being traded. But we also realize that the current regime, the current laws we have in place in many aspects, they still kind of work with the presumption of paper. So the old idea, a share or a security has something to do with a paper. Obviously, there are electronic forms to it, but the law set was still very focusing on this paper idea, which didn't really fit in the new world of DLT technology. And what the Federal Council did, and that's the executive body of our government, so the highest body, they conducted we can call it gap analysis back in 2018, where they analyzed what we need to amend in Switzerland in the existing legal framework to be fit and proper to deal with digital assets, with DLT, blockchain-based assets. And they kind of identified quite a big amount of a delta, what would be good to have and what we currently have. And then this delta or those gaps have been filled by a so-called DLT framework regulation. This regulation, as William pointed out, is not one piece of law. It's amendments in roughly 20 different pieces of law, covering all different segments. So we have, just to give you a bit of an overview on that, we have amendments in the banking regulations. We have amendments related to the custody of digital assets. We have amendments in the bankruptcy regulations to kind of assess in case of a digital asset, a cryptocurrency or a security is being held by a custodian, what happens in case of a bankruptcy scenario. We have amendments in the AML regulations. We have amendments in the financial market infrastructure regulations. We have amendments in the civil law. This is what we're going to talk about today, which addresses DLT securities as such, and the creation of these type of asset token. So there's been a whole different set of regulations, and some of them are smaller changes, some of them are bigger changes. I'd like to maybe, before moving into the DLT security space, look at two other bigger changes which have been implemented. One is certainly what I have mentioned, the way how custody providers for digital assets are being regulated in Switzerland. When do they need a banking license? When do they need a FinTech license? And in which scenarios can you hold third-party digital assets or without falling into either of these license categories, but you only qualify as a financial intermediary, which is important for many business models around FinTech and blockchain. Another important change, and we're also going to address that a bit later today, is the introduction of a new secondary market license focusing on digital assets, focusing on DLT securities in particular, but also utility token and payment token. So we have a new form of exchange venue for these type of token. And of course, last but not least, one of the key changes is certainly the introduction of the so-called DLT register right to DLT securities. Maybe Luka, if you can take over from here to introduce the concept, what is a DLT security?
Yeah, thank you very much. I'm gladly taking over. One of the, let's say, aims of the new law was to actually produce something which is functionally equivalent to a security certificate, something you can hold and transfer, not physically, but rather digital. So that was the aim, to find a solution how we can do that on a secure legal new basis. And the legislator in Switzerland has chosen to deal with this aspect in civil law. So it is a civil law concept which they use. They use the old legislation concerning the certificates and adapted the legislation to the new, what we called registered securities. So on one hand, it is a contractual concept, which is based on which actually this new registered security is created. And on the other hand, there are also new technical aspects in the law. So the civil law aspect of this new registered security is a contractual concept. So the basic concept is a contractual regime between an issuer and a holder, a creditor holding a right embedded in a digital certificate. So that's the contractual part of the DLT, or let's say the registered security. They created a new concept of a register contract. That's the register contract has to contain all elements of the registered security, the way how it will be transferred, what the content of the right is, and so on. So on one hand, it is this contractual element which has to be embedded into a contract, and the contract needs to be accessible by all the participants, by the issuer, as well as of the creditor and third parties intending to use this certificate, the new digital certificate. On the other hand, the law mentions several aspects. In the course of drafting the lawmakers in Switzerland wanted to be as technology neutral as possible. So they avoided to use specific terms like blockchain or DLT, but tried to describe what are the relevant elements in the technology, or the technology elements which have to be in place in order to say, okay, here we have a registered security. One element is the accessibility. The technology must be in a way that the creditors have full access to the technology, so they can access the token. In addition, the technology must be set up in a way that it can ensure integrity. The integrity must be ensured by technical as well as organizational means. That means, the content of the respective law must be immutable and clear, and only the creditor can have access for a transfer and not the issuer. In addition, the law did not define but set it up as a requirement that the content of the law, for example, if you have a share and the share is like 1 share of Luka Müller AG, nominal value 100 out of 10, this legal relevant information has to be somehow connected to the register, the technical register information. Use here, for example, blockchain. You need to have a technical connection, a secure, reliable technical connection between the legal relevant, very often off-chain information with the on-chain transaction. Again, based on how we do the law in Switzerland and based on our civil law principle, this is not a detailed description how it has to be done. This has been left to the industry to further define, but they actually defined it as a principle. And then ultimately, what it has, another, let's say, technology element which has been defined in the law is that the creditors have to have always access real time to the information which is connected to the DLT transaction, so that they can every time, all the time, real time control and also view the information connected. So you have accessibility, integrity, the connectivity between off-chain information, on-chain information, as well as accessibility of the information connected, as the technical, let's say, description and requirements which lawmakers embedded into the new law. So if you talk about the new registered security in Switzerland, you have a contractual concept in the law and a technical description of the technical requirements, but principle-based and, as I said, left open for the industry to define. This new article, it's Article 973D of the Swiss Code of Obligation, as I said, it's based on a civil law principle, is now in force since February 1st this year.
Luka, can you talk a bit more about the technology aspect? Is it correct, do I understand it, so that they leave it up to the company to implement the right technology? Like, where does the burden of implementation fall? Like, are we going to see multiple implementation of this? Let's talk a bit more about the technology implementation aspect.
Yeah, it's very interesting. In the beginning, let's say in the first draft, the lawmaker were always referring to DLT and blockchain. And then it was clear this might be a bit too limited and too narrow to describe all the technical options which possibly also in the future pop up. So they try to actually be as generic as possible in technology in the description. And that's why they use the way to define what they think should be the functionalities in order to actually allow an equivalent of a physical certificate. So to answer your question, they did not say, okay, use Ethereum as a platform. use a hyperledger or Coda or whatsoever as a platform. Not even they said, what is because the law is actually is mentioned, the title of the law is distributed registry. So they did not even define what means distributed. Is it 1, 2, 3, 4, 5, whatever nodes? So they actually left it really open to the industry, and there were some working groups and comments made in the course of drafting the law, but it was deliberately left open, and I think that's a good thing, to say, okay, it will be then up to the public to decide whether or not, or even a judge later on in a civil law case, if let's say a creditor will claim, you issued as issuer a registered security, but what you use, the technology used, it actually does not ensure the requirements which were defined by the law. So no clear technical requirements. At the moment, there are many initiatives in Switzerland, and one is an initiative called 4T DLT, for trust for DLT. They are about, and we can actually discuss a bit about this a bit later on, but because it gets more really technical, they are now trying to define the basic requirements for a configuration of a smart contract, of a distribution of what is distributed, of the requirements of a protocol platform, requirements of a custody solution and things like this. So that's actually, as I said, in the process now, left open by the industry to define what they think would fit as an underlying technology for such a registered security.
And to add on that from my side, it's also from how Swiss legislation processes work. Switzerland has a very principle-based legislation, so Swiss law tries to avoid setting in stone too many technical details, because they develop quite fast over time. So you always need to run behind the technology. So it's really a principle-based approach also here to say, what do we need to see? And it's up to you to develop the technology which fits it, or use the technology which fits it. So when we look at the different examples we're going to go into, they're using different now, when we talk about blockchain, they're using different blockchains. One example uses the Ethereum blockchain, other uses other blockchains, more private blockchains. So we see everything, and everything has its right to be there. And I think the market will show for what type of digital securities or DLT securities, what kind of ledgers are the appropriate technical forms.
So do you think this will lead to the implementation of implementation standards? As you mentioned, the standards body that's now doing its work. And it's one of the questions that just came in. I was thinking about that, because otherwise you can have multiple implementations, which could be good if they're all going along the same path, but at the same time, it might be challenging. So do you think that this will lead into a one standard way of implementing, which would then leave it to multiple technologies to come into play?
I think they're going to be standards. They all need to meet the same regulatory framework. They need to kind of meet the conditions set by the law, which are somewhat broad. I think over time that will be further defined by practice. But we're going to have different standards for different regimes. We're certainly going to see platforms, because not everybody wants to issue their own token with their own technology. This is not very efficient. So we're going to have different platforms using different technology standards. And then I think the market will show which ones are going to survive.
Look, I can actually take also the view of a regulated intermediary. So if you, as a regulated intermediary or licensed intermediary, want to touch a security token, or let's say a registered security, you have to adapt your own internal AML system, your internal risk assessment, your system, how for the best execution, market systems, and you have to write all these internal regulations and make the risk assessments. And that was one of the other aspects of the initiative for DLT, because we will have to have, banks or intermediaries accepting these kind of tokens. We will have internal law departments dealing with it. We will have auditors actually auditing what the banks did. And then we have the supervision authority, supervisory authority have to deal with it as well. So what we did, in the 40 DLT initiatives is actually to help them to understand what are the elements to assess the technology, and then to actually to also then assess which technology, which platform you will use for which application. For shares, for example, would be probably another than for a gold token and things like this. That's one aspect. And the other aspect is what we already deal with already now, and we did a proof of concept already last year, is how to deal with different protocols, because we don't think that there will be only one protocol in the whole world. So we will think, as we have different big exchanges, and we see that already, we have some of the already traditional exchanges which try to step into the DLT world. Some of them believe in Corda, others believe in Hyperledger Fabric. The more modern institutions like a Signum, for example, believes in Ethereum. So we will see. What will definitely will be one of the challenges, both technically as legally, will be the change from one protocol to the other. But here we need to prepare that we have to work with multiple protocols in the future as a technology platform.
So who is the most advanced right now in terms of, can we talk about examples? Because when it comes to the blockchain, as you well know, what comes to mind when you implement it is user friendliness. And the blockchain, as it's on its native basis, is not very user friendly, except it is powerful to technologists. So I would be very interested to see how we apply this to make it really as easy as anything for a business user to use it, right?
Yeah, I mean, these are really the challenges. We saw that by setting up daura.ch. And at the beginning, we thought, we have an ERC20, it's easy to do. Let's configure an interface for the issuer and provide an easy wallet solution for the shareholders holding the digital shares, But it's not as easy as that, And especially the standards in the connection of the off-chain information with the on-chain information is a challenge. How do you do that in a way that first they are connected, the smart contracts are connected with this information. This information can be made visible for the issuer as well as for the creditor. And that was a bit a challenge for us at the beginning, and also now we were actually the first one issuing such a registered security, actually 12 midnight and 1 minute February 1st this year. And then we had to draft all these, also the contract, and there were so many open issues. So I say version 1 is now out. Daura is working as a version 1, but there will be a lot of developments, And then we did the version, also a version 1 version is the one we did on Signum, which is based on Ethereum. But this is, I would say, a much more sophisticated version, It's because, here we did not only design a smart contract which is able to transfer rights. We added additional functionality into the smart contract, like exercising of governance right, like voting, receiving of dividends. So it really depends on what kind of, and I think it will be like in the past, it was the printing machine of a share, and the printing the paper. So you have some traditional printers, they printed, let's say, shares in the quality of the toilet papers, or shares in the quality of a really good certificate. So we will see in the future which configurator will prevail. At the moment we have, I think, Andreas, please correct me, we don't have many at the moment. I think I know only Signum and Daura running.
No, there's some more, I think there are probably around 5, 6 on the market, which...
But really operating now?
Yes, in the process, yes, operating and working. With some have more sophistication, some have less. And I think what's important to keep in mind, we've been talking about DLT securities in the framework of shares, so issuing company shares on the blockchain, for example, as an asset token, and this is one use case, obviously. This DLT securities can have very many different use cases. They can represent a claim to particular commodities, like an asset-backed token, other claims. So, and what we see that on the market was happening, that those platforms which are now being scaled up, they focus on particular segments of security. So let's say daura, a good example to how to issue a DLT share token. Other platforms focus on maybe asset-backed token with commodities in the background, because that's what they could do better, because they need a different system. You don't need a governance system implemented if you don't have a share, if you don't have an equity right with a governance right attached to the security. I think that's going to be a key differentiator. Also, what market do you focus in as a platform? And we also see platforms or developers who have in other jurisdictions, like in Germany, Liechtenstein, and in the UK, who now are adapting their technology to start meeting the Swiss requirements, so they can also be player in the Swiss market.
Sorry.
We have one question from the audience, which was the question from Paul. Paul is with regard, would it be, whether we agree that the creation of a market participant ecosystem, so I guess in some form of a trade association, could speed up development of integrated DLT technology solutions in this area? I would like to answer that. I don't fully agree, but I'm curious to hear Luka's voice on that, of course, as well. I think we have various trade associations, and they have been very important kind of on the political and the lobbying level to help us and with government establish the new regulations. I think, however, when it comes to the implementation of the technology, the market is probably much faster than associations ever will be, because the associations generating the funds needed for the development work, because it is a substantial development work. It's rare that they have the funds, and they tend to be slower on the end because they don't have the market exposure. So I do believe here the market is probably better suited for that purpose.
Yeah, again, I have to refer to the example of the 40 DLT initiative in Switzerland. You know, we used one of these associations, Digital Switzerland, as a platform to organize these specialists of all other associations, industries, and organizations to help us to gather all the information to actually draft this information basis for a possible future standardization. So what we said is, in phase one, what we do in this initiative is first to create 4 films, actually 4 films, easy understandable, but this is for the broader stakeholder community. Like I said, the auditors in the world, the regulators, the politicians, the future issuers and the future holders of digital shares, you know. So it's actually more like an easy explain part of video. And then the second part, what we're doing now is drafting a white paper describing all the elements which I described briefly in describing the law. And the aim to produce this is using all the forces from industry and the organizations to set up a basis based on which you then, if you have an association or you're an industry, to create then the standards. And I firmly believe, you know, and Switzerland is actually a very good example of it. You know, in 1976, we were drafting our AML and anti-money laundering standards faster than the regulators, and they are still applicable. So I think if the industry works together, they can actually react faster than the regulators. It would be a disaster if we would left it to the regulators and supervision authorities to actually direct us which technology, which standards which we should use. So fact, I think the industry and the market has a really dominant role to play here.
What is the role of the regulator, specifically FINMA, in this case? Are they following, or are they monitoring, or maybe you can comment on FINMA specifically and regulators in general? I mean, you just said that this seems to be that the market is leading here, and are they following fast?
Okay, well, maybe let me try to give an answer to that, and also kind of give a bit of a regulatory overview. And I think it also would be time to address another question without the digital asset taxonomy, which rose from the audience. So principally, what Switzerland does, we distinguish between the three types of token, and I can just quickly put here a slide on so you see that. Can you see that now, my screen, William?
Yes.
Okay.
So basically, we differentiate between payment token, asset token, utility token. Payment token, as you can read, is a means of payment. So Bitcoin, for example, would be a payment token. Utility token is a token which is intended to provide access to a blockchain, a decentralized infrastructure. So Ether, when you look at it from a gas perspective, would be a utility token, as it's now being used as a mean of payment as well. It also is a payment token. And then you have this whole set of asset token which represent some form of a counterparty claims. And the taxonomy question which arose for the audience, the answer will be that's the taxonomy. And when we talk about DLT securities, we are in this asset token space in a nutshell. And what does that mean from a regulatory level? If you issue those DLT securities yourself as an issuer, you're not regulated. You may be subject to a prospectus duty, and I can also just give you a bit an overview here. What does that mean? So basically, prospectus duties, they arise if you have a public offering, and obviously, as you familiar with, I assume, from other jurisdictions, you have exemptions to that. You have one set of exemptions if you have qualified investors or just a low number of investors, below 500, and you're accepted to provide a prospectus if you have certain threshold-related exemptions applying. So if the denomination of one unit you sell is below 100,000, or the investors purchase more than 100,000, or you raise less than 8 million. This is the regulatory regime around token. And if, again, you don't have any licensing obligations, so you don't need to go to FINMA and ask for permission whether or not you may issue your own token. So FINMA is not really relevant in the primary market issuance process. Obviously, they will monitor the market, but it's your own obligation to comply with the laws.
Okay. Let's talk about whether does this apply just for Swiss companies, or what are the implications for non-Swiss companies and also for non-Swiss investors? Does this mean that, does it have any legal implications for US-based or other global investors to purchase these DLT-based securities, Swiss securities?
Okay. Well, principally, the two questions. One side is kind of the view from it's all cross-border questions. They're obviously cross-border questions the answers tend to be in legalese and very complicated. So I'll try to keep it simple. And Luka, please just add on your thoughts or interfere. So if you look at it from a investor's perspective, the question is, can I, being not a Swiss resident, purchase Swiss asset tokens, Swiss DLT securities? The short answer is yes, you can. Then the long answer is, well, it depends on where you live and how this jurisdiction treats that purchase from a regulatory perspective. And the even longer answer will be, if you look at it also from a Swiss issuer perspective, do I get into trouble in another jurisdiction if I target that market, or can I rely on a reverse solicitation exception? and that's all combined together. It depends, of course, but principally, yes, you can purchase DLT securities issued in Switzerland, and as a Swiss issuer, you can also sell them into other jurisdictions, but you need to be careful that you comply with the applicable regulations there, which may and is likely to result in a prospectus duty also in those jurisdictions, because that, with regard to securities, that's rather common. The other questions from your end was, well, can I issue a Swiss security without being a Swiss company? Here again, I think we have a long and a short answer. Short answer would be principally yes. Is it advisable? Probably not that much, because due to the kind of international private rules, the question is, can you really successfully tie Swiss law to the issuance of a security being done by a non-Swiss company and rely in the enforcement that Swiss law is really applicable, or will a foreign judge simply then apply the law in the jurisdiction where the company is or the client is? So that would be my response to that.
Want to add anything, Luka, or that's it? I can go to the next question.
I think that's more it. I mean, there you have one basic principle is if you always have to ask your own lawyer in your own jurisdiction, because, you know, if you offer something, you know, outside of another country into another country, the question whether or not it is an offering which is designed to the residents of such a country is always decided by the laws of the respective country. So it's very difficult, and there's really a variety of different practices in all different countries. And we know US is a little bit specific here. Others have a bit other points, but that's the challenge. Actually, it's the challenge of the future of the global digital asset market. Because this digital asset market with the technology which you have is always globally, always, you know. And here we will also have a very, very big challenge in the future, how these different jurisdictions, not only from a regulatory point of view, but what I'm fearing as well from a tax point of view, deal with these digital assets in the future in a global environment.
Great. Let's talk a bit more about the future implications of this going forward. And one of the questions that came in was about the impact potentially on decentralized exchanges like the Uniswap of the world. And I understand, I mean, this is private share. These are private shares, so they're not technically tradable or publicly tradable. But do you see now an impact potentially because the barriers of entry are much lower for decentralized exchanges? What would prevent or is it possible that now some of these shares would end up seeing themselves being traded on decentralized exchanges potentially?
Yeah, of course. You know, if you have this will be one of the big, and is already is, you know, some of the big challenges of the regulators, how to deal with it, you know, because if you have a digital representation, a decentralized digital representation of something like a share, you know, you can feed this digital representation with whatever smart contract you have. And if there's such a smart contract system, let's use the term smart contract, but if such a system has a decentralized exchange functionality, in fact, you know, you would not need to have a regulated exchange, you know, and this is, you know, this is a typical already existing DeFi issue which we have at the moment, also with let's say the crypto DeFis, you know, and here this will be a huge challenge for the regulators to deal with the fact that they haven't any control anymore over these exchanges, over these exchange functionalities. So what we see already is a tendency to enlarge the jurisdiction of the regulators in a way that they already try to find a way how to sneak in to regulate the development and the deployment of it, you know, because they know that the actual operation is decentralized and can't be controlled anymore. So we will see in the future. At the moment, we have many projects on the desk to deal with the, here now with the FINMA, with our financial, with the local financial market authority. But this is a challenge. And, you know, we have another project which we try to find also a bridge between the CFIs and the DFIs in order to give an answer to the, because, you know, if the regulator is unhappy, you can avoid a regulator, but this is not a long-term sustainable solution. So if you have to work together, but you need to actually please the fears they have. And I think version 1 of the bridge between CFI and DeFi needs to be done. So to a certain extent, integrating such a DeFi into the centralized world. And this will be the challenge and also the innovation in the future.
Yeah, I mean, the first step is to put these securities in the inventory. Right now, the inventory is very low. So the first step is to have a multitude of examples and options. But then later, I mean, one of the issues will be liquidity. When you talk about decentralized exchanges,
Absolutely.
somebody to fund the liquidity aspect. So if there's just one person wanting to sell their shares and nobody else there to be in front of it. So I think this is an opportunity to create new types of services. But how far are we from this?
I think, you know, I mentioned at the very beginning that we have next to this new DLT security, as we call it today, also a DLT trading venue license, so a new form of license. It's a centralized exchange. And so it's not a DeFi exchange, it's a centralized exchange working similarly to a stock exchange with one key difference that the type of assets are different. So we have the digital assets, we have these digital securities, but we also have all types of token, which can be traded, payment token, utility token can be listed on this exchange. Plus, the exchange can serve retail clients, unlike current stock exchanges, which have banks or financial intermediaries as their clients. So it quite basically replaces the need to go through a broker or a regulated financial intermediary to participate and trade your own securities or digital assets which you hold. And I think that's quite a big step, because I think that's the only regulatory regime which focuses on having a crypto exchange, including security tokens. I think that's new. However, it is a centralized way. It's CFI, as Luka mentioned. And the question really is, how can you integrate those security token into a DeFi environment on a long-term basis, but already on a short-term basis? Imagine if I think this works quite well with regard to asset token, which don't represent any equity rights in a company, for example. But as soon as you have company shares, you need to maintain a shareholders registry, and you need to know who your shareholders are, and if they trade your shares on a DeFi, on a Uniswap, that doesn't really work. So we do have projects currently working on exactly this solution, try to kind of include security token, now DLT securities, in a Unify or other DEX setup in a form that we can, on one hand, make use of this liquidity of the market, of the efficiency of this market, but on the other hand, also meet the regulatory requirements to be able to kind of keep a proper shareholder registry as a company in Switzerland. So this, I think, a lot of energy is being put in those types of secondary market projects right now.
Does this have impact on the identity requirements? And this ties into one of the questions that came in, which is, how is identity addressed in Swiss law, specifically online identity and on-chain identity, privacy on-chain? Can you talk about that? And does it have to tie in then?
Yeah, as Andreas said, it really depends on the type of assets. If you have a share, digital share, then you have the FATF requirements, not only the civil law requirements to keep your shareholder registry up to date, but you have FATF requirements to actually keep it up to date. So you need to have a synchronization between transfer and your share registry, which limits the possibility of a non-ID transfer, because we know two types of transfer. An ID transfer, this is a transfer from an ID address to another ID address, and the non-ID transfer. Nevertheless, depending on the technology you use and the platform you use, it might also be possible that you have also, let's say, some in the line of transfers, non-ID transfers in an ID environment. So for the shares, it's clear you need to have an ID connection or an interconnection between your ID and the transfer. This is actually by law, you need to have that. With other assets like debt instruments and things like this, you don't need that by law, So, but here, since it here really depends whether or not you hold these assets directly, If you hold these assets directly, then it's not an issue. But if as the moment you use an intermediary service like a wallet service, then it will be again a challenge to do all these identification. And then we are back to the old KYC AML world.
This could tie in with the concept of wrapped tokens. And again, a question has prompted this, and I'm changing it a little bit. As you know, there is a concept of wrapped tokens where you can wrap BTC to get them to trade on the Ethereum compatible networks or on other such exchanges that support Ethereum ERC20. Could that be maybe one implementation is to wrap these security tokens to allow them to, it will open up a lot of liquidity, basically.
This from a tech perspective, yes, absolutely. That's actually what some of the projects building up trading venues in Switzerland do. They say, well, we want to remain technology neutral. We simply wrap basically all the tokens which come in to be able to trade them on our platform, which may be a private blockchain at the end of the day. So that would be an approach that. From a centralized perspective, the other view again would be, well, what would be the effect if I use as a token issuer an open blockchain, because only then I can take out the token, wrap it, and put it on another blockchain. What kind of effects does it have on the share registry, and what kind of consequences does it have if I have a new token holder which I'm not able to identify in order to get him to be a shareholder? And I think that basically is a two-step approach, that you may hold the token and hold the share, but you may not be listed yet as a shareholder because you have not been identified. And until then, you simply hold the share, but you can't make use of the associated rights.
There are two types of wrapping. One type of wrapping is you wrap the same right on another technology protocol. Okay, so you have the same share, it's wrapped, but actually transfer another protocol. Here you need the full synchronization. Or you wrap the token and issue a new one and issue a new product. So you say, okay, this is more like a financial instrument. So you don't transfer the share will always locked and wrapped in, but you transfer only the right to the share. So that's a new instrument, So this is the two types of wrapping you have.
Yes, definitely. I think this brings a lot of innovation possibly to the space that hasn't been implemented yet. But then how do you reconcile the private aspect with the public aspect? Because these methods of trade we're talking about are more in the public domain. Or are we saying that there's going to be still something private in that process that will not be revealed as long as the authenticity of the transaction is of the public domain? I'm not sure if I'm saying it properly, but there is a bit now, we're mixing private and public.
Look, there will never be, there will always be a challenge between the issuer and the creditor 1 and creditor 2, because they need to have a certain identity. You need to be identified, otherwise you cannot actually exercise your rights. So in this bilateral relationship, to a certain extent, you need to have identity and visibility. However, according to the law, it's not requirement that you have a transaction visibility. So that's a difference. I can transfer a digital share from A to B, and actually I as A know, and you as B know, and the issuer knows that it actually has been transferred from A to B, but that's it. You know, the public doesn't need to know that there was a transfer.
So the concept of
public protocols, you know, this is a challenge for the public protocols, because in the public protocols you would see it, you know.
But it is not. So what happens to the history? How do you preserve the historical integrity of the actual trade? Somebody has to know this history. No.
That's done by the smart contract or the register, the shareholder register. But this is not public.
Correct. Okay, but it is preserved.
Yeah.
Yeah, I mean, obviously, if you use a public blockchain, you have the transparency. It's preserved on a blockchain. If you use a private blockchain or another ledger technology, then it's there, but simply not public.
Okay. What's the status right now? Do you see a lot of companies rushing to do this? I mean, is it like a novelty? Is it more of an efficiency driver? And what happens if you have thousands of shareholders? It becomes a bit complicated, right? So it's not like for the average club that has, I don't know, 2,000 members. It's more, is there a sweet spot there? Can you talk about that?
I mean, for us, William, the law is overdue. No, this is, and we are happy that it is now really in place, and we can work with it, and we have now legal certainty that we can actually transfer digital assets really on a very secure legal basis. But take into account the following: the law has been enacted February 1st this year, so it's really like it's like a baby, young and fresh, you know, new, and so what we see is the new, and let's say that the young technology company, they are much easier to adopt it and to say, okay, oh, quite interesting. And for the older, let's say, for the more, let's say, conservative companies, it would take a bit more time to actually use it and see these tremendous advantages you have by a digitalization of your shares, because you always have a clear. You always know your shareholders. Always, always know the whole history of transfers. The shares are easy transferable. The transfer costs are much cheaper than the physical compared to physical transports. You can actually easily implement employment share schemes. Also, let's say, using a digital share as a certificate to show that you have the governance rights, that you can vote in remote general assemblies. So a lot of, let's say, efficiency gains, but I think it will take quite a time until this has been received by the industry.
Yeah, and it's also fair. I mean, it's not a speed race we're in here. I think these new regulations, they kind of build the grounds how shares and securities are being issued in the future, in the next 50 or 100 years, possibly even. Looking back how long the old law was applicable. So I think there's no need for a company now to immediately shift to digital shares. That there must be a certain benefit to that move, because it also involves costs. But nevertheless, I think for a new company which is being set up, it's a no-brainer that you have that in the statutes, that you have the possibility to do that, or even already do that at the time of issuance, because their costs are the lowest and the benefit the highest.
Can you
many shareholders, as you pointed out, thousands of shareholders. We do have some projects in that regard, and it proves for some of them to be difficult to even find their shareholders, and without finding them is a bit difficult to give them a new digital share.
Can you talk a little bit about the costs? I mean, of course, the cost of transactions are much lower, but how about the cost of implementation, the initial costs of getting into this? And I know we're early. Usually it costs more when you're early. Anything there?
Yeah, it depends on what is your target? What do you target? If you say, okay, I have a small company and I want to actually issue now digital shares, and I want to do it because I'm modern, I want to have a full history of my shares, but I probably have only 10, 15 shareholders. It's another case, but if you have already 1,000 shareholders and want to do it. So daura, for example, I think it's around 1,000 Swiss francs per year to actually configure your shares in a way that you have registered securities afterwards. It's a configuration of your own smart contract, which you will get. It's about 1,000 Swiss francs.
Okay, so it's reasonable.
It's reasonable. It should. I mean, it should be. That was also the understanding. It should be a commodity. It should be a very easy service. It should be compared with the costs actually to maintain a shareholder registry. Probably a bit more expensive because you have more functionalities. But it should be like what you use as a costs as a corporate secretary to keep your shareholder registry up to date.
Yes. A quick question, maybe one of the last ones, and then we're going to wrap it up in about 3 minutes. A few months ago, we had a similar seminar on the concept of DAA, Distributed Autonomous Associations. Can you draw any parallels there, any relationship, or is this like another kind of two interesting projects now that exemplify how the blockchain can be used?
I mean, yes, the projects are different. They are similar in a way that we have to connect off-chain information to on-chain information. That's actually, there we're similar. So we have off-chain legal relevant information, which can become relevant once connected to a functionality on a blockchain. I think here it's similar, whether it's an association or an AG. In addition, we have also certain additional functionality like voting, governance, which is quite similar to a share. But apart from that, I would say it's a different concept. In the DAA, we were using quite a sophisticated set of smart contracts to enable to run a decentralized autonomous organization or association based on a smart contract system. That was more the aim. Here, what we have is we're using a smart contract to issue a multifunctional modern digital share. So it's actually there are two different cases. One is really issuing an asset.
So if I'm understanding correctly, obviously the governance aspects and the change management aspects are more sophisticated and more implementable in the DAA side because it's more of a DAO-centric model, whereas here the focus is more on the transfer of ownership.
Yeah, absolutely.
Maybe also I think the DAO structure is one particular vehicle how to structure kind of a DAO-like organization under Swiss law, which great project, but here we're talking about basic legal concept when it comes to DLT securities, and it's about a new type of civil law financial instrument which bases on a new technology which can be used for all types of financial instruments, being that shares, being that any other types of rights. So I think it has a much broader application perspective than now the DEA has.
Okay. Can you answer one question, like very, very quickly, and then I'm going to wrap it up. Was there a change in the audit in the new DLT legislation?
Change in the audit?
Audit.
Well, no.
Okay. No. Very simple. Okay. So we're approaching the hour. I want to thank everybody for coming into the seminar and thank MME, Andreas and Luka for participating, and Nadine and Thomas for behind the scenes. And this is brought to you as part of the Token Summit initiative, which is still in a hiatus for the second year due to COVID. We hope to come back live and physically one day when everybody is vaccinated and everybody is safe. In the meantime, be safe out there. And this is a very exciting initiative. I'm going to be following it. Especially, I'm very excited about the standards implications. How do we implement and roll out these standards so that it becomes very user-friendly to put shares on the blockchain and to transact them and so on. So thanks again, everybody. Have a good day, good evening, and rest of the day. Bye-bye.